Oh, please come forward. Good afternoon.
Good afternoon, Judge Clement. May I reserve 3 minutes for rebuttal?
3 minutes, certainly.
Thank you. May it please the court, I'm Mike Richardson from Chattanooga, here on behalf of the appellants, plaintiffs in this cause, Julie Buhler and her bankruptcy trustee, David Rogers. This case is an appeal from the Davidson County Circuit Court, and it involves a claim of legal malpractice which Ms. Buhler brought against her former attorney, Stephen Lefkovitz, with the Lefkovitz and Lefkovitz law firm. The claims for legal malpractice arise out of Mr. Lefkovitz's former representation of Ms. Buhler in a real estate dispute she was involved in that ended up in Chancery Court in Davidson County. We're here because the trial court committed reversible error when she effectively sua sponte granted a summary judgment motion filed by the defendant on an issue that was not even raised by or asserted by the defendant. The trial court found that the plaintiff, even though she had established duty, breach, and damages, had not shown cause in fact or proximate causation flowing to her as a result of the defendant's malpractice. In so doing, the judge basically ignored some findings of evidence she made based upon evidence the plaintiff submitted in response to the defendant's motion for summary judgment, and improperly totally relied upon a bankruptcy court opinion that was authored 9 months after the facts, after the time the malpractice was committed, and after 9 months after the damages were caused by the defendant's conduct. That bankruptcy court should...
Can you have causation, cause and fact, legal causation, where there's not a legal right in any sort of enforceable sense, but as a practical matter, you may be able to obtain that relief by way of settlement because of complexities, for example, with having somebody move out of a house where you don't have a legal right anymore, but you may still be able to get the settlement. Can you have legal causation in that scenario?
I'm not sure you can, Your Honor, but that's not the facts that we have here. Here's the factual background. Ms. Buhler in 2016 entered into an installment sale contract to buy a house from her neighbors, which she did purchase. She ran it as a bed and breakfast at Airbnb for several years as income producing property. And she paid $30,000 down, paid payments for 4 years, and then had a balloon note come due at the end of 2021. She did not make the balloon payment, and she therefore was in default under the installment sale contract. Under the terms of the installment sale contract, there was a default provision that said if she was in default, she would have 10 days to cure her default after being given notice. So the seller, Ms. Davis, had her attorney Joe Rusnak, send a notice January 24, 2021. The seller's attorney sends a notice of default to Ms. Buhler under the party's contract. She immediately hires Mr. Lefkovitz. He files a complaint in Chancery Court to set aside the notice of default under the contract documents. That's where the malpractice occurred, because when Lefkovitz filed the Chancery Court complaint, he filed it within the 10-day cure period and put in the complaint that Ms. Buhler, who had the funds, she had now procured the funds. The balloon note was about $310,000. She had obtained the funds from a wealthy friend of hers, and she was now able to pay it off. He filed the Chancery Court complaint in a timely fashion and stated in the complaint that the funds necessary to pay off the note would be paid into the registry of the court. Unfortunately, he failed to tell the client to do that, and she didn't know to do it. And that's when the malpractice and the causation occurred. We submitted evidence, and this is referred to in the court's memorandum of opinion on the summary judgment. On page 14 of the court's memorandum of opinion, the trial court referred to some of the evidence we adduced in response to the defendant's motion for summary judgment, and she stated that Ms. Davis, the seller, had testified that it was her understanding that the plaintiff would be entitled to the property if she performed all material obligations within 10 days after receiving notice. We also submitted an affidavit from the seller's attorney, Joe Rusnak, and the trial court said, additionally, Ms. Davis, as the seller's attorney, stated that had the plaintiff tendered the funds necessary to complete the real estate transaction when the Chancery Court case was filed, he would have advised his clients to accept it. And then the trial court courts on the, and this is important, the trial court then states, each of these pieces of evidence indicates that had Mr. Lefkovitz advised his client to tender the funds into the clerk's office, as the complaint said would be done, plaintiff would have likely been entitled to the property. Well, there's causation right there. But for the defendant's failure to advise his client to pay the funds into court, which she had, in which the complaint said she would have prevailed. The seller would have taken the money, the Chancery Court case would have been dismissed, she would have the property today. There's cause and fact and proximate causation. But cause and fact, of course, is but for.
But getting back to Judge Usman's question, if your client was, if your client's failure to pay the December payment installment and clearly stating to the sellers, I can't make the balloon payment, I just don't have the money. If that constitutes anticipatory breach, which terminates the contract, then your client has no legal right to rely upon to say that, well, the sellers might have accepted this had Mr. Lefkovitz said, show them the money. It's speculative at the very least. Probable, but speculative.
Well, and the burden is more likely than not by preponderance of the evidence. It's important to note that all the parties to the contract, the seller, Ms. Davis, Ms. Buhler, purchaser, and all their attorneys, when the Chancery Court case was filed in February 2022, none of them thought the contract had terminated. They all thought that notice of default had to be given and that Ms. Buhler had 10 days to cure the default. They were all
It's my understanding when the case was tried in the bankruptcy court, the seller's wife, the survivor, said that she didn't know that she had to give notice of default. She didn't know that was an option until the question was presented to her in bankruptcy court, is the way I recall.
The testimony was a little different. Ms. Davis testified at the subsequent bankruptcy proceeding that she wasn't clear about the contract. She testified that her husband, who was deceased, was a former real estate agent, and he had drawn their own contract. But what she did admit was that when shown the contract, she was read the contract, she goes, yeah, I understand that if she defaults, I still have to give her notice before I can avail myself of the sole and exclusive remedy, which was to retake possession of the real estate and to keep all the money Ms. Buhler had paid her for 4 years. And that was her testimony. She admitted her understanding was that notice had to be given. And Your Honor, it's also important to note, in the Chancery Court litigation.
But didn't she say that before that question was asked her, she didn't understand it that way?
She said she was asked a different question about had Ms. Buhler waived her rights. And she said, I think she waived her rights. But then when she was shown the actual contract, she goes, oh, no, you're right. Which is why she then admitted that's what.
So her state of mind before that question was presented was that the contract was terminated. But
or that Ms. Buhler had waived her rights to do anything.
Yeah.
But then when shown the contract, she clarified that, she had a right. And Ms. Davis testified that's why she sent Ms. Buhler the notice of default. Because if the contract had terminated, as the bankruptcy judge concluded a year later, she didn't have to send her a notice of default. She could just have repossessed the property.
Well, I think there's little doubt that Mr. Lefkovitz should have handled this case differently and could have tried to negotiate a settlement. But as Judge Usman's question suggests, if the contract was terminated and there was no duty to give the 10-day notice, or or the 10-day notice had expired before your client even hired Mr. Lefkovitz. Does any of the ifs, ands, or buts matter after that?
Your Honor, the contract had not expired according to all the parties. The first person that
Well,
raised...
was it the 10-day notice that was delivered on January the 24th? Wasn't that before Mr. Lefkovitz was hired?
Yes, it was.
And didn't the 10 days run before Mr. Lefkovitz was hired?
No, Your Honor. He was hired like the day after January 24, and he filed the chancery
I've
court.
looked through the record, and I can't find the day Mr. Lefkovitz was hired.
He filed the chancery court complaint like February 2, 8 or 9 days after the notice was received by his client.
All right.
So he actually filed the chancery court complaint within time. And again, that's the malpractice in the cause and fact, because all the parties thought Ms. Buhler had 10 days after getting the notice of default to cure. And Lefkovitz actually did the right thing. He filed a complaint within 10 days. The negligence was he didn't tell the client to pay the funds into court, which she had, because he had this other idea. He wanted to put her into bankruptcy and litigate a separate issue as to whether the installment sale contract was an executory contract under applicable bankruptcy law. But back to the chancery court case, when he filed that and failed to have her pay the funds into court, that's when the causative effects occurred. She had 10 days to cure. That's what all the parties were operating under, that assumption.
But is there evidence in the record that she had the money?
She did her uncontradicted testimony. She had the money.
It's my understanding she kept saying, I can get it, I've got the money, but she didn't have the check until
She didn't
weeks
get
later.
That's the trial court, I think, got a little confused on that. The chancery court case was filed February 2. Ms. Buhler has testified uncontradicted that she had the funds available and could have paid them in court had she been told to. She didn't actually get a cashier's check until Lefkovitz filed the chancery court case February 2, and he didn't even serve the people for almost a month. So they didn't even know that a lawsuit had been filed to cure the default within 10 days. In the meanwhile, Ms. Davis filed a detainer warrant because that's her remedy. If she doesn't cure within 10 days, then you could file a detainer warrant and get your property back. She filed a detainer warrant, which came up for hearing in General Sessions Court in mid-March. Lefkovitz goes with her, and that's when, for the first time, he told her, get a check and bring it to Sessions Court. So she had the funds available. She just didn't take possession of or bring a cashier's check until mid-March. But she always had the funds. And the reason the trial court erred so badly is cause and fact and proximate cause both occurred in early February when the lawsuit was filed. And you've got, we submitted an affidavit from the seller's attorney saying, had the funds been paid into court when Lefkovitz filed that chancery court case, I would have told my client to take it. And Ms. Davis thought she had the right to pay it off anyway, so that would have ended it. Ms. Buhler would have prevailed. She would have kept the property, and she never should have been put into the bankruptcy, which is another whole story. But after the malpractice occurred, the damage occurred after the 10 days ran, and Lefkovitz did not have her pay the funds into court to cure the default. After that, it just goes off on a sad trail. Lefkovitz puts her into a bankruptcy. He wants to litigate this issue about executory contract. And then the bankruptcy judge 9 months later, on a totally different issue, makes a finding that the trial court improperly retroactively applied to override what actually happened in February. And I see I've gone over my time. So
We'll hear
I'll
from
stop.
you on rebuttal. Thank you. Good afternoon, Mr. Long.
Good afternoon, Your Honor. May it please the court, my name is Jason Long from the Knoxville Bar. I'm here on behalf of the defendant Lefkovitz and Lefkovitz, the law firm that has been sued in this case. It is clear that the court is up to date and well up to speed on the record in this case. I want to point out a couple of matters that I think need some clarification. First of all, Mr. Richardson noted that Ms. Buhler's attorney, or excuse me, Ms. Davis's attorney at the time of the default letter being mailed had said that if full payment had been made of the back money owed on the contract, I would have advised my client to accept that in resolution of this matter. That's not exactly what her attorney told her. If you look at the record, what he said was, if payment of the back fees were made, as well as attorney's fees and costs, as well as interest, as well as potential penalties, then I would have advised my client to consider accepting that in resolution of this matter. He does not, in fact, say he would have advised her to take it. That's an interesting and important distinction in this case, because as we make representations here about the parties' understanding as it existed in February of 2021, it's important to note that this was not a done deal. The attorney for Ms. Davis had not advised her that she should resolve this matter, that this right to cure was in place. In fact, as Your Honor has noted, in the bankruptcy proceedings, Ms. Davis was very clear that she did not understand that there was an enforceable right to cure under any term of this contract at the time that Ms. Buhler went into default. In fact, Mr. Hildebrand, who was the attorney questioning her in that proceeding, asked her 5 different times, did you understand that there was a notice to cure or an opportunity to cure? Was there an opportunity to cure under this contract? The first 4 times, she continually answered, I don't understand. It was my understanding that Ms. Buhler had waived that right, that there wasn't an opportunity to cure. And then, like any good lawyer would do, Mr. Hildebrand brought out a copy of the contract, had her read it on the stand where it mentions notice provision, right to cure, and Ms. Davis finally relented and said, well, that's what it says. I'm not a lawyer, but that's what it says. There must have been a right to cure. So that goes to the very point that at the time of the events in February of 2021, it is apparent that Ms. Davis did not believe there was an enforceable right to cure.
Counsel, there are practical complexities in getting somebody out of a house, litigation cost, expenses, challenges, time that it's going to take. Let's assume for purpose of argument that there was no legal right that was held anymore by Ms. Buhler to be in possession of the property, but she was in actual physical possession thereof. If a lawyer provides counsel that otherwise would be malpractice, can you have causation in that circumstance of an injury where there's not a legal right, but as a practical matter, it does make a difference? And I understand you're disputing that it
Sure.
actually makes a difference consideration, but let's assume sort of, I know I'm asking you to go a couple arguendos and assumptions here, but can you have a causal action where there's no legal right, but as a practical matter, an attorney may be able to obtain some kind of relief for a client?
Well, Your Honor, first I would say I don't think in a legal malpractice action, if there's not an enforceable right there, I don't think a lawyer can be held to have caused any injury. So I don't think that you can have causation. However, and I think Your Honor's question goes to, well, would a good lawyer go in and try to resolve this, outside the terms of the contract? Let's just get this done for everybody's best interest, and maybe there's a possibility to do that. Perhaps, but the facts of this case don't lend themselves to that, because what we know in this case is that Ms. Buhler made several attempts after December 31st to pay off this contract, and she was rebuffed by Ms. Davis time and time again. Ms. Davis never offered to accept that money. So to the extent there could have been a negotiation, we'll pay the fees, we'll get this done, and you won't have to worry about finding a new renter or a new purchaser or anything like that. While we ultimately will never know, because the facts don't tell us, what we do know is this Ms. Davis never offered to accept or never indicated a willingness to accept the funds from Ms. Buhler. And Ms. Buhler testified that she offered to pay several times after December 31st. So our position would be that there's got to be a legal right to be enforced in order for there to be causation. But even if this court were to accept that there is some standard of care or duty of lawyers to properly negotiate outside the bounds of the legal contract, we would still say causation doesn't exist here because there's no proof that Ms. Davis was ever going to accept any amount of money.
Is there any proof that she wouldn't, that Ms. Davis would have a rejected, and if Ms. Buhler shows up with the money and she doesn't have a legally enforceable right anymore, that Ms. Davis would have said, no, I'm not taking it at this point, I want the property back?
Other than the fact that she did, in fact, reject overtures to pay her money after the attorneys got involved, that would be the proof that Ms. Davis was not inclined to reach a resolution under any terms proposed, but that would be our proof. The record simply wasn't developed on that point. But again, our position is that if there's no legal right to enforce, then there can't be causation. Because what we do know is that Ms. Davis did not accept any payment for the property. She did not believe at the time that she had the ability to, that there was any kind of right to cure, and her attorney even advised that he would have advised her to consider, but it would have been more than just payment of the contract price. It would have been payment of the attorney's fees, the interest, the penalties, none of which Ms. Buhler ever indicated she had the money to pay or the willingness to pay during the course of these proceedings. Another point that ought to be clarified, and I think—
Before you go on to your next point, do you agree with Mr. Richardson that Mr. Lefkovitz was hired the day after the plaintiff received the 10-day notice and that he filed the chancery action within 10 days of the 10-day notice?
We agree that he was hired sometime after the January 24th letter and within the 10-day period after the January 24th letter, because he did file the action. I have combed the record as well, Your Honor, and I don't think anyone knows the precise date. Even Mr. Lefkovitz and Ms. Buhler, I don't think they know the precise date, but they know it's in that window.
But it was within the window. Thank you,
That's
sir.
correct. One other factual point that I wanted to point out was whether or not Ms. Buhler had the money, had possession of the money to make tender payment at any time, either up until December 31st or thereafter. And Mr. Richardson points to her testimony that she could get the money, that she had people who were going to assist her in funding, but it goes back to the point that she never actually testified that she had that money in her hands, that she had it to give to Mr. Lefkovitz or to give to Ms. Davis until the March hearing on the detainer action. That's the first time that Ms. Buhler acknowledges that she actually had possession of the money. And again, that's the money to satisfy the terms of the contract. It's not the money to include attorney's fees or interest or other things that Ms. Davis's attorney at that point would have been counseling her client to consider if she were going to accept resolution of this matter. From my client's perspective, and I think from the perspective of the trial court in this case, the critical facts are that an installment sales agreement had been entered into, that Ms. Buhler was required to make her balloon payment and complete that contract by December 31st, 2021. She failed to do so and in fact acknowledged that she was incapable of doing so, which effectively terminated that contract. Once that contract was terminated, she had no right to cure, and by the time that she hired Mr. Lefkovitz in late January of 2022, causation had already gone out the window. There was nothing that he could do to prevent the legal situation that Ms. Buhler was then in, and therefore he did not cause or contribute, either from a cause and fact or approximate cause analysis, any of the injuries that Ms. Buhler complains of. Now, in the trial court's opinion, and Mr. Richardson has referred to it, the trial court did rely upon some findings made by the tax court, or bankruptcy court, some 9 months later. Now, we've argued in our brief that causation, unlike standard of care and breach, which has to be evaluated by what the standards are at the time of the events, causation is binary. Either you caused an injury or you didn't cause an injury, and the passage of time does not change that. Just because the bankruptcy court was the first to acknowledge 9 months later that what occurred back in February did not cause or contribute to Ms. Davis's injury does not mean that it's not true or not enforceable or does not guide the court in this case. Now, the appellant has argued under the estate of Billy Hawk case that the reliance upon this bankruptcy court opinion by the trial court constituted reliance upon inadmissible hearsay.
Reliance on the findings of fact, if I understand.
Well, it's the appellant's position that reliance upon any of the findings, whether fact or conclusions of law, of the bankruptcy court was inadmissible hearsay. The first point I'd make is that when analyzing whether or not evidence constitutes hearsay, of course, we use an abuse of discretion standard with respect to the trial court's findings for evidentiary matters. And what the trial court did is true. When the trial court first entered its opinion with respect to this case, it adopted several of these salient points that are elsewhere available in the record, and just adopted them from the trial court opinion. When Mr. Richardson filed his motion to alter or amend and brought to the court's attention the Hawk case, the court amended its ruling. It decided that it didn't need to rely upon the findings of fact of the bankruptcy court opinion, but still did rely upon the conclusion of law. That conclusion being that the contract had terminated and there was no right to cure, so that by the time Mr. Lefkovitz became involved in the case, there was nothing he could do to prevent the injury that had occurred. Our position would be consistent with the trial courts, and that is a conclusion of law can't be and is not hearsay. Courts rely upon decisions by other courts all the time, whether it be in appellate proceedings. If I cite to you the Billy Hawk case, I'm relying upon findings of fact or conclusions of law, at least, with respect to that case, and this court is entitled to rely upon them. If, for example, you had a divorce action, and I think we cited this in our brief, if you had a divorce action and the juvenile court in another matter had determined paternity of the father, the divorce court's entitled to rely upon that determination of paternity. So it happens all the time. It's not a factual determination that is guided by our hearsay rules. It's not subject to the criticism and critique that we put our hearsay rules in place to prevent. That is, we don't have to concern ourselves with the credibility of the findings of law of a bankruptcy court like we would the findings of fact, and that's why we have the hearsay protections in place. So our position would be that unlike the Billy Hawk case, where the plaintiffs were actually trying to use factual statements and determinations from a tax court to question witnesses and to have them be admitted under judicial notice, here the court is relying only upon the conclusion of law. And the conclusion of law was this is not an executory contract. It terminated December 31st, 2021. The latest period upon which a notice of cure or default could run was 10 days from that date, which would be January 10th, 2022. Mr. Lefkovitz was not retained until after January 24th, and therefore there's no ability to prove causation or cause in fact or proximate cause in this case.
Did the trial court make an independent finding that the contract terminated, or was it based upon collateral estoppel from the bankruptcy court?
The trial court never got to, we raised a collateral estoppel argument in our motion for summary judgment. The trial court stopped short of ruling on that issue once it had made the determination that because this contract, as noted by the bankruptcy court, terminated December 31st, there was no cause in fact, and there was no proximate cause.
But to split hairs, did the trial court make its own finding, or did it say, well, I agree with the bankruptcy court, or I'm going to follow the bankruptcy court?
My recollection, it says, based upon the bankruptcy court's finding that this contract terminated December 31st, there can be no causation. So whether you consider that an independent relying upon the conclusions of the bankruptcy court or just relying upon the bankruptcy court, it's essentially 6 in one and half a dozen in the other. What I would say is that even if this were a hearsay issue, the law provides that if it's a harmless error, and here this court, the trial court, have all the facts that the bankruptcy court did and have the ability to make the decision that the bankruptcy court did, that is, this contract terminated. And therefore, even if it were hearsay for the bankruptcy court to make the statements it did, which we don't believe it was, it would be harmless error. because the facts substantiating the fact that there's no causation or no cause in fact in this case are admissible as admissions by Ms. Davis, or excuse me, by Ms. Buhler in her deposition and the testimony that's gone before. My time is up, Your Honor.
Your reliance upon January 10 as the drop-dead date, that presumes that a notice of default wasn't given, just that it's an automatic 10 days. Is that right?
No, Your Honor, I'm relying upon, actually it's a statement from, I believe, the trial court opinion that at the very latest, because the contract terminated December 31st, presumably at the very latest, had a notice of default been sent on that date, they would have potentially gotten an additional 10 days from that date, but it didn't happen in this case. So I'm using that as the very outset.
Bottom line, you're basically saying we've got anticipatory default that terminated the contract
Yes.
As of December 31, and no notice was necessary.
That's correct, and it should be worth noting that even the notice that was given did not indicate that a default or that a cure provision was in play. It didn't offer to allow
The notice of default actually, if I read it correctly, said we want possession within 10 days. It didn't say, I don't think it said you can cure within 10 days.
It did not, Your Honor, and that's consistent with Ms. Davis's testimony in the bankruptcy court where she said time and time again, I thought Ms. Buhler had waived that ability, and it wasn't until an attorney made her sit down and read it line for line that she acknowledged there may be a right to cure.
All right, thank you.
Thank you.
Mr. Richardson, am I correct that the 10-day notice was a demand of possession, not an offer to cure by payment of the balloon note?
The notice letter did not say anything about you have a right to cure. It says you have defaulted.
And we want possession in 10 days, yeah.
And everyone has characterized it as a notice provision, a notice. In fact, when Lefkovitz filed the Chancery Court complaint, he styled the complaint a petition to set aside notice of default. And I think, let me come back to a real key question about was there a legal right when Lefkovitz filed the Chancery Court complaint and committed malpractice, what legal rights does Ms. Buhler have? Well, the parties all thought she had legal rights. No one ever thought the installment sales contract had terminated until a bankruptcy judge found 9 months later in assessing whether it was an executory contract that had terminated. At the time of the relevant events, at the time the Chancery Court case was filed, at the time the malpractice was committed, and causation has to be assessed and evaluated at the time the malpractice occurred and the damages occurred, which was February of 2022 when the Chancery Court case. Everyone thought she's got a right to cure. Ms. Davis begrudgingly admitted that upon cross-examination, but causation is a question of fact. Cause and fact is a question of fact. Proximate cause is a question of fact. It's crucial that the trial court, in her memorandum opinion, and I read this earlier, the trial court referred to some of the facts we had put into the record, and the trial court concluded each of these pieces of evidence indicate that, given this, the plaintiff would have likely been entitled to the property. That's causation there. Now, I didn't move for summary judgment, but at a minimum, that's a question of fact for the jury to determine as of February 2022. It wasn't until 9 months later when the bankruptcy judge ruled on a different issue. As I mentioned, Ms. Davis thought she had a legal right to cure, or she wouldn't have had her lawyer send that notice letter. Joe Rusnick, her attorney, thought that because he filed a motion to dismiss in the Chancery Court case. Didn't say and it's in the record. I put it in the record. Rusnick filed a motion on behalf of Ms. Davis to dismiss the Chancery Court case, but it wasn't predicated upon any notion that Ms. Buhler did not have a right to cure. It was predicated upon Lefkovitz had also alleged that a violation of the Tennessee Home Mortgage Act. So that's proof in the pudding. No one thought that Ms. Buhler did not have 10 days to cure. And you've got to assess causation at the time it happened. not with the benefit of 20/20 hindsight from a bankruptcy judge's opinion 9 months later, they shouldn't even be admissible. If Lefkovitz thought she had a right to cure, that's why he filed the complaint, a petition to set aside the notice of default. When Miss Buhler came to him with that notice letter, Lefkovitz did not say, "Oh, ma'am, you don't have time. The contract expired 6 months ago." No, he took her money, and he filed the complaint and had her pay the money into court. The proof is more likely than not that she would have won then and kept the property. That's when the damage occurred. After the 10 days ran, time ran out.
All right.
But
All right. Thank you, Mr. Richardson and Mr. Long, for your
Thank you, Your
arguments. We'll take this matter under advisement. Call the next case, please.